Hello and welcome to the Herrington Carmichael Employment Law Update for September 2017. My name is Alistair MacArthur. I'm the head of the employment team with Herrington Carmichael. I hope you all had a lovely summer. We were expecting a quiet one, but actually it's been quite busy from the employment law front. I've got my usual 4 key things for you, so here we go. Let's start with the Parental Bereavement Pay and Leave Bill, which was presented before Parliament during August. This is intended to give parents who unfortunately lose children at a very early stage of life the right to leave and pay. This is going to be a new employment right. It's going through Parliament. We'll update you when it becomes law. Next, I've got 3 cases. The first one involves suspension, and it's the case involving the London Borough of Lambeth. This case deals with the issue of whether suspension is a neutral act or not. In this case, it was found that suspension wasn't a neutral act, and really an employer should consider whether there's an alternative to suspending an employee as part of a disciplinary procedure. Now, to some of you this may seem like common sense, but actually we're recommending to clients that whenever they are suspending employees, they're making clear, good reasons as to why they should suspend, and there's nothing more that they can do. Second case is the case of Dudley and Metropolitan Borough Council in Wilts. This is a case involving holiday pay and the question of whether overtime should be included in holiday pay or not. This is dealing with the issue of voluntary overtime and reiterates a point which we already know, that if voluntary overtime is going to be included, it's got to form a regular pattern so as to become normal remuneration, and that means that it would be included into holiday pay. If you think that you've got employees who are regularly working voluntary overtime, you'll need to look at this and make sure you take it into account. Finally, the case of Traythorne and the Secretary of State of Justice. This involves a religious belief discrimination claim where a Pentecostal Christian was sharing his views in a prison. In this case, the individual failed to demonstrate that a group of people sharing his protected characteristic would be disadvantaged compared to others who do not share his protected characteristic, and his claim failed. This is a reminder that indirect discrimination claims are very, very difficult for people to pursue successfully, and even in the field of religious belief claims, they're even more so. If you have individuals who are sharing their religious beliefs in the workplace, you need to consider very carefully what you do with that and potentially take some advice, because there are still risks. That's it from me this month. I hope you all have a very good September, and I'll be back with you at the start of October. Thank you.